lot.
Exciting.
All right, we are back live. It is Tuesday afternoon.
Thank you.
We'll start over again with a very short intro. So today we're just going to, this first hour, or now 50 minutes, will be kind of a mock, because this is a bill from last year. And so we're just to do kind of a mock introduction. I just wanted you to experience what this is before we start, because tomorrow we have our first bill introduction on a bill that we're likely working on. So I just wanted to go through this so that the process was clear. So with us today is Representative Robin Chestnut-Tangerman from Middletown Springs, who's going to introduce H416. And this is a bill that he fictionally is bringing forward to us today to ask us to take a look at it. Robin.
Well, thank you, Chair Stevens. For the record, Representative Robin Chestnut-Tangerman. I'll be talking to you about a bill that I will introduce with the words you should never say about a bill, but this is a simple bill regarding abandoned swimming pools. And I will read the subject, the statement of purpose in the bill, and then leave the actual language to the Ledge Council. But statement of purpose is this bill proposes to require that all abandoned swimming pools be drained and completely enclosed by a 5-foot wall, fence, or barrier. A person who violates these requirements is subject to a civil penalty of not more than $100. So that's what the bill does. What I'm here to talk about is why it should do that. And basically, an abandoned swimming pool is an accident waiting to happen. It's legally an attractive nuisance. It's a magnet for kids in the neighborhood. It's a magnet for wildlife. If it has water in it, it's a breeding ground for bacteria and mosquitoes, a vector for disease. So it's not just, at that point, it's no longer a personal possession, but it can potentially impact the entire community, neighborhood. In Vermont, there is no requirement that swimming pools be fenced, even active swimming pools. So there are an unknown number of abandoned swimming pools which are currently not fenced. These pose certainly a huge liability risk for the homeowners. Either personal injury or wrongful death suit waiting to happen. So preempting that by fencing these accidents waiting to happen is not just responsible homeownership and stewardship, but also responsible for being responsible to your entire community. Because the goal is not to defend against a lawsuit, but to prevent it and to prevent injury or damage to anybody. There is a cost involved. Cost varies depending on what kind of fence you want to build, but it's generally between $1,000 to $3,000, which is a lot cheaper than defending a lawsuit, as well as the stewardship point that I mentioned earlier. So at this point, we don't know how many in-ground pools there are in Vermont. This is obviously abandoned pools are a small subset of that. So potentially a small number of affected individuals, but certainly a danger or hazard worth preventing, in my opinion. And I thank you for your attention to this. And I don't know if you have.
I have a couple questions, and again, thank you for bringing it forward. How do you determine it's abandoned? Is it abandoned on someone's property? Is it as if the pool owner has stopped using it as a pool?
For a period of a year. So it doesn't have to be drained to qualify as an abandoned pool, just not in use for over a year.
Representative Parsons?
Yeah, I just had a question with that language. Say my neighbors have a seasonal home and the pool's being maintained, but due to family circumstances, they're unable to make it up for the summer. Pool's open, it's being maintained by the company that takes care of the lawn and everything else. Would they still fall under this category of an abandoned pool if they didn't make it up that summer?
No, if the pool is being maintained and ready for use, then I would consider it not abandoned.
Okay. Because the language says not used, not in use. Nobody will be using the pool, so.
But that's a good point.
Thank you.
Representative Krasnodar.
All right, I'm gonna throw you a little curveball. As a former skateboarder, many of my friends have used pools to then have a skateboarding pool. What about those? Would those be considered abandoned if people are skateboarding in them?
Are these privately owned or publicly,
Yes.
privately owned pools?
It's not
I
as
think-
popular in
yeah.
Vermont where we can't outdoor skateboard year round
Year-round.
as in Southern California, but it does exist and I have been.
I think that's a great question for legal counsel.
Okay. Sorry.
No, that's good.
Representative.
I mean, it's a great question because it's a consideration that I didn't think of when I had the bill drafted.
You said in-ground pools, does this cover above-ground pools also?
No, this is specifically in-ground pools.
And if they are using it as a skateboarding venue, if you will, if there's no water in it, would it still be underneath it? And it doesn't have to have,
It doesn't have to have water in it.
either way, okay.
So a pool without water in it is still an abandoned pool,
Okay.
to Representative Krasno's question.
And if an individual, let's say the pool's got a crack in it and it's too expensive to repair, if they fill it in with gravel, do they still need a fence?
That does not, I think then it no longer poses a
Okay.
risk.
Okay, Representative Latham.
Thank you. Enforcement. You're going to turn this over to a municipality through the zoning administrator if they have a zoning plan? I mean, how do you, who's the cop that's going to go around and check everybody's property?
I need to check my bill on that one. A municipality may adopt and enforce a swimming pool ordinance that is equal to or more stringent. So that's additional enforcement. That is,
That's a may, right?
that is a may.
Shall.
Yes, that is a may.
That's enabling them to be more strict.
It's a civil violation.
Right.
I would refer that question to Ledge Counsel.
It's Representative Howard.
Do you know how many states have the law that you must fence in a in-ground pool?
An active pool? A majority of states, but I don't have that number in my memory. But we're not the only state that doesn't require it, but the majority do.
And if we take up the bill, we can certainly do that research to find out where we've hit. If we take up the bill off the wall, we can find out, we can do that research.
Right. What I should say here is I'm happy to get that number figure for you.
But we know you won't. We'll have to get that by ourselves. No, I appreciate you coming in. I know that there's probably been, like, if I remember reading the news properly, I think that there's been an incident in your district or near your district where people may have gotten hurt, near this, near a pool.
Which is, often the case that's the catalyst for something like this. But probably in everybody's district, there is a similar incident waiting to happen.
Well, you can tell that we're already asking questions, and this is a This is just a sponsor's presentation. We know that you're not going to be the one that we're going to end up getting, if we take it off the wall. We'll get the appropriate witnesses. If there are specific people that you want us to call in, please let us know. But thank you for.
Real life, I would provide that list for you.
But bringing it forward to a bill opening like this is always a celebration that, sometimes it's because of potentially terrible circumstances that we ask for something like this. But I'm glad that you're trying to be proactive and trying to prevent things from happening. So we'll see. But we'll have more questions, I'm sure, for legislative council. And if we take it off the wall, we'll let you know.
Thank you, Chair Stevenson. Thank you, committee.
Thank you.
Thank you.
Thank you.
Next up is Eric Fitzpatrick.
Thanks. You bet.
Okay. And Representative Barley, you have the bill?
I do.
Eric, welcome back to our new committee room.
Thank you very much.
I guess you would be coming back to it, at least with us in it. Anyway.
Yes, it's true. I remember it was corrections and institutions previously, right?
Yes.
Remember, right? Yeah.
Last year, or
Right.
last biennium.
Yeah.
So this is a bill that you wrote, and if you could just take us through it and in your way and just explain to us, one of the things that I want people to understand is where does this, it says 20 VSA chapter 209 is added to read. And so I just want to, give us a feeling of, in this case, this is a new section to the bill, to that section or to that chapter. And if you could just explain how things get inserted sometimes like this, and also when it's just sort of a phrase that's inserted into something, that where the context is of this proposal in the bigger picture.
Yeah, happy to. And thank you, Chair Stevens, and for those folks I haven't met, my name is Eric Fitzpatrick. I'm an attorney with the Office of Legislative Counsel. As the chair mentioned, I work most often in the judiciary committees and in matters related to the courts. You can see that the legislation they looked at is connected to the courts in the sense that not only is there criminal or at least prosecution in the Judicial Bureau, civil prosecution actually, there's a liability piece to it that I think is related to what we do in the judiciary arena as well. And as the chair was mentioning, the Title 20, and does everyone sort of backing up a little bit? Does everyone know that the green books up there, which are the codified Vermont law, are divided by subject matter? And we refer to them by title because it's sort of shorthand. But, and I don't think off the top of my head tell you what the subject of each title is, but each title has its own subject. So Title 20, I know, is public safety, which is why the proposal is to add a piece related to public safety into the pre-existing Title 20. That's what this bill is proposing to do. But, the other titles are arranged numerically to cover their own subject matter. We most often in judiciary will cover Title 12, court procedure, Title 3, the criminal code, Title 27, property. So each one has its own subject matter. And when you look at a piece of legislation, this one, for example, if you look at page one, does everyone actually have it or on?
Right behind
it. There you go, even better. If you look at line 14 of page 1, you'll see what this bill is proposing to do is to, VSA stands for Vermont Statutes Annotated, by the way. So that's, or as we refer to them, the green books. And that's, so Title 20 refers to volume number 20. So if you went up to those green volumes on the wall there and counted up to number 20, if they're in the right order, you'd come to this one. And it proposes to add a new chapter, chapter 209, you see. So there's an existing couple of hundred chapters in there, and this is proposing to add an entirely new one. So you'll see that within that chapter, it's proposed to be added, there are sections. So if you look at line 16 of that first page, it proposes to add section 4701, 4701, and there's a few others after that, which I won't go into. But as the chair was mentioning, this particular bill proposes, at least in the first section, to add an entirely new chapter. Just for a second, before we get to the substance, I'll just to show you how this works. If you page down, please, to the very bottom of page 3 over onto page 4, because there's something else that has to go on in this bill in addition to adding this chapter about abandoning pools. Because as Representative Chestnut Tangerine was indicating, this bill, or I should say the offense that's created, which is the offense of not complying with the requirements of what you have to do to when you have an abandoned pool, which is basically fence it off and drain it, right? Those are the two big picture. You got to drain it and you got to enclose it. Those are the two things that are required. And if you don't, then it's what's known as a civil violation. Not a criminal offense, but it's a civil violation. And that happens to occur, and those civil offenses are compiled in a different title of those green books, Title 4. You see at the bottom of page 3, section 2 of this bill makes a different amendment to existing law, to a different title. Because you've said, if you just look above on page 3 there, it's lines 16 through 19, this language says, what's the penalty? So what if you don't enclose the pool the way you're supposed to? And we'll get into what you have to do. But what if you don't drain it and enclose it the way that you're supposed to? What's the consequence? The consequence is, you'll see line 70 to 18, you're assessed a civil penalty of not more than $100, and every day constitutes a separate violation, which means if you keep doing it for 2 weeks, that's $1,400, right? It's $100 a day, potentially. Up to, that language means that's not a requirement that the court impose exactly that penalty, but that's the maximum that the court can impose. So, but in this case, actually, I'm misspeaking in a sense, because it's not the criminal division of the Superior Court, it's the Judicial Bureau. And the reason for that is because it's a civil penalty, not a criminal offense. And civil penalties are adjudicated in the Judicial Bureau, and that's like a traffic ticket. It's a civil violation. A violation of a municipal ordinance is a civil violation. Those are prosecuted, for example. I think that was a question that was coming up earlier. Who's going to bring this, right? Some civil violations specifically provide that they're going to be brought by the municipality. This one doesn't, and that's something that the committee can talk about, is you could do that. And that's actually one of the, I think, great benefits of the walkthrough. It kind of reminds me of a law professor I had. I had a great quote. He called it the life is rich principle. You can't anticipate when you're drafting legislation, or when you're even passing legislation, you can't anticipate every conceivable fact pattern that's going to arise. So to the extent you can, though, while we're doing the walkthrough, that's great, because then you can note things and think, oh yeah, you're right. Or, what about skateboard parks? Or who's going to enforce it? Or what about the vacation home? Things like that weren't necessarily accounted for in the initial draft. I make note of those generally during a walkthrough. And so then if the committee chooses to, you can say, well, we should put some specific language in here to address, say, a home that's seasonal or something like that. Or maybe you'd say that, in use as a pool or something like that. So that skateboard use would not be covered. Or, there's different ways you could go about it. Or you could specifically say, this will be enforced by the municipality. If you didn't, though, just to answer the question that you had earlier, who enforces this? If it doesn't say otherwise, the civil violations in the Judicial Bureau, absent some specific direction to somebody else, are going to be enforced by the state's attorney or a police officer who writes the ticket. So the court, the Supreme Court, and the Court Administrator's Office has this form Judicial Bureau civil violation ticket. And on the back of it, I date myself as to how long I've been here. When I started the show, there was something like 6 or 7 offenses on the back of that thing. And there's like 35 of them now, because it's become kind of the go-to for the legislature. When you're like, we want to make a penalty for something, but we don't want it to be a crime. Judicial Bureau. It is kind of a middle road. You can sort of have a consequence that can be something that builds up on a person, particularly if you don't pay the fine. You don't necessarily want to be in that situation. But it's not so bad that you're going to have a criminal record, or that you're going to have all the sort of attendant consequences that come with having a criminal conviction. So that's a long list on the back of that ticket now. And if you didn't say otherwise, then that's the way this would get enforced. It would get added to that list on the back of the form, and a police officer, law enforcement officer, or a state's attorney could bring that charge and prosecute it in the Judicial Bureau. That's the way that would work. So anyway, last point before we get to the mechanics of the bill. So you see there, if you kind of go now over onto page 4, actually, I was guessing, but yeah, 30, you'll see. So that list that you'll see a number 30 of on line 5 and 6 of page 4, so if this bill were to pass, it would become the 30th civil violation, because there's 29 before that one in existing law. So you'll see that line 3, the Judicial Bureau, and does everyone know that lines 1 to 3, because they're not underlined, are existing law? So that's how that works, right? So when this is not a new chapter like the first section was, right? The first section was an entirely new chapter. Every word was underlined. This section, section 2, is making a small amendment to an existing section of law. So that existing section of law is Title 4 VSA 1102, which is the jurisdiction of the Judicial Bureau, which lists all the types of offenses that the Judicial Bureau can hear. And there's 29 of them right now. This proposal is to add number 30. That cross-reference, line 5 is a cross-reference to the first section of this bill. 20 VSA 4701 is the proposal to add that new section dealing with what? Abandoned swimming pools. So if this were to pass, the Judicial Bureau, by operation of subdivision 30 there, would then be able to hear these kind of cases. Somebody brings,
So this is a contextual thing. Those 3 dots are just basically telling you that there's a gap, that there's other material between the colon from following matters down to 30. So this is where this is out of context. This is just a standalone number 30, but there's 29 other offenses, or whatever you want to call them. And this also points out that I'm sitting here going, why did we get this bill if it's a judiciary bill? And it could have happened because we're under general.
right?
The Judiciary Committee either might have had a full plate of other issues, or because this doesn't really fit except for the Judicial Bureau piece of it directly, it came to us. Matters that don't easily fit into other sections. But if we were to pass this bill, it would go over there because it has a reference to the Judicial Bureau. This is the cross pollination of we won't pass a bill in this committee that has things like fees or penalties in it without it getting checked by a different committee. So we're expected again to be decathletes in a way. We have to learn the swimming pool law or the laws around it, the real estate laws, the insurance laws. But in the end, this bill will get reviewed either by what's called a drive-by, which is us just showing the Judiciary Committee the bill where they want it. We'll just show it to them and get their blessing, if you will, or the clerk will decide that it needs to go over to Judiciary for a full review, and then they would own the bill. So that's just sort of the directions. Thank you. That's just the directions of where this simple little bill can go.
Yes, thank you, and thanks for reminding me about the asterisks in the middle as well. So yeah, those we use because there are times when you're drafting a bill when it might be helpful to have the context of the existing law that's not being changed. And so we'll reprint, when we're putting the draft together, we'll put it in there if we think it might be helpful for you to see that, to sort of better understand whatever the change is. In this case, those asterisks on line 4 are only taking the place of the 29 existing Judicial Bureau offenses, which would take up a lot of paper to put that here. And do you really need to see that? Is that really helpful that much? Probably not. So that's why it's not there. It's sort of a judgment call each time as to whether
It's available there.
And it's right
Or
there.
online.
Or online. Exactly. Right. For sure.
Representative Lamont.
And so you wouldn't need to see them because this is standalone. It's not relevant to the others and those are already in place. So that's why you would use that because those are not being altered and they don't affect the standalone.
Exactly. They're not being changed at all. Yeah. If it's being changed, we would have to put it in for sure. But yes, we use that to sort of show that there is some existing law that exists out there, but it's not being changed by this bill. And you probably don't need to know about it to understand what's really going on.
Okay.
Yeah.
Thank you.
And that said, if you want to do your homework or extra homework, you would go look up what the context is online, just to see if, well, what if this is a Jenga piece? And what if it does affect number 17? You know, you could do that. I mean, we're trusting the attorney to have done the research on the bill to get to this point. So perhaps in their nonpartisan opinion, but on policy, they could say this doesn't apply to anything else. This doesn't counter, indicate any other piece of the bill. But we could still check it and see what the context is and see if it does for our own sake. But at this point, I would start by trusting legislative counsel that they did the research to get to this point, but we're all fallible and
not only that, not only am I and all of us fallible, but you might legitimately see it differently. That's happened to me plenty of times when folks will say, oh, all right, let's take a look at that, and maybe they'll look at it, or I'll make a copy and send it to them, or email a link, whatever. And they'll say, it might really, actually, I think it would be helpful to have that in the bill, to have it just for context. So, it's totally fine to see it differently. And, just so I don't think anyone in our office we all are happy to have more eyes on it, more points of view. So if anybody thinks it would be helpful, then we're happy to add it.
okay.
Yeah.
Representative Labor.
Thank you. I don't see anything in the bill that would represent fairness to the landowner, like prior notification of a visit from an inspector, or can we fly a camera-equipped drone over your house and take a look at your pool? So there's privacy statutes involved here that probably should be inserted in that bill.
Are you insinuating that this is not a simple little bill?
I'm insinuating that it may have potential.
So committee, again, that is the perfect, and again, there's also the context of, like, we would never grill the sponsor on stuff like this. We would never grill him because, of course, he might just be asking to put something in by request of a constituent. So he's not going to be a subject matter expert. He will have asked. Eric will have been assigned the bill. So we're learning what's in the bill. And then when it gets to this point, that's what witnesses would be for, when we start to break it down. Because Eric can answer, but the answer is always going to be, well, that's a policy question. That's up to you. And that's
exactly what my answer was going to be.
and so that's just the process of of how we get through to, we don't have to get to the bottom line of what the bill is in the first day. We just need to have a quick understanding on the first day. It's just a quick understanding of the bill as it's being presented. And so can you just start with the walkthrough?
Yeah.
Just do the walkthrough before we're gonna stop at about 10 of.
Sure. Happy to. So with that as background and turning to the walkthrough of H416 itself, it's an act relating to abandoned swimming pools. Just a moment of background, because a lot of times people think, well, where did this come from? There's a number of municipalities with similar ordinances. I haven't actually seen any other state laws on this, but there's quite a few municipal ordinances that impose some obligation on what someone has to do with an abandoned swimming pool. So we used a couple of those, and I say we because I had a law clerk who would help me with this when it was first drafted a couple of years ago. So that's the genesis of it. But the mechanics of how it would work, as I was mentioning earlier, basically it's imposing a requirement to do two things with an abandoned pool: drain it and enclose it. And if you don't do those things, then you're subject to a maximum of $100 per day civil offense. So that's the big picture. Obviously, what's crucial to that then is going to be, how are these terms defined, right? What does abandoned mean? And you can see, and I know that was mentioned earlier by Representative Chestnut Tangerman, it has to be continuously unused for 1 year. That's in the definition of abandoned swimming pool. You may want to think about what you mean by unused in response to a couple of questions that have come up. Unused for what? You could easily flesh that out if that's what you wanted to do. Swimming pool itself is defined, a couple of crucial points there. In-ground, remember that question came up as well, has to be an in-ground structure for swimming or recreational bathing, and water has to be over 24 inches deep. So you'll see later on, there's a specific exemption for kiddie pools. So it has to be 2 feet deep at least, and in ground, not above ground. So that's your definition section, subsection A. Again, for purposes of reference, when you see those small letters on line 17 of page 1, the very first thing is called a subsection A. When we get to 1, that's a subdivision. Everything after the subsection is a subdivision. So now on line 5, we are on subsection B, right? Subsection A was the definitions subsection. Subsection B is your requirements. Now, what are the requirements? We've gone through that already. Abandoned swimming pool has to be drained of water and maintained without water for so long as it's not in use, and protected by an enclosure. So you got these 2 requirements that apply if it's an abandoned swimming pool. So the requirements only kick in after a year of being not in use. Then subsection C, you'll see, gets into some really specific requirements because, the term an enclosure surrounding the pool area, that's in lines 8 and 9, that's pretty general. So what does that mean? Well, that's what subsection C talks about. You'll see it's very particular, very specific about what it means for to satisfy this enclosure requirement. And another interesting sort of general point, you see in subsection C1, lines 10 to 11, this is a common drafting tool. You'll see this quite a bit. An abandoned swimming pool required to be enclosed as provided in subdivision B2. That's a cross-reference. That shows what these following requirements apply to. What do they apply to? An abandoned swimming pool required to be enclosed in B2. So if you fall under B2, if your swimming pool falls under, in other words, have to meet the definition of abandoned, first thing, right? And the definition of swimming pool as well, meets both of those, then these requirements kick in. And this is saying if they do, well then, here's what the protections have to be. What are they? Lines 11 and 12, enclosed by at least a 5-foot wall, fence, or other barrier. So 5-foot tall fence or barrier, that's number 1. Number 2, what about this fence or barrier? Has to not have any gaps, openings, indentations, etc., that could allow a young child to crawl through. So crucial piece of what it means to be enclosed. This 5-foot wall, but not just any 5-foot wall, has to be constructed in such a way that a child is unlikely to crawl through it. And, pardon me?
I mean, the snarky question would be, well, what does young mean?
Right.
So that's,
Right.
you could keep going.
Good point. No, that's a good point. Yep. Another term that probably ought to be further defined.
And why is there a 24-inch loophole? Anybody, you could drown in a puddle.
Yes, right. I think that is probably something that is mimicked from another ordinance somewhere else, but.
You don't have to fence your puddles.
That's what this says, though. You don't have to fence your puddles, right? This is the kind of, it's not snarky.
No,
It
yeah.
can be, but it's not snarky in the sense that this is the place where all possibilities, usually the most negative ones, you start thinking of, well, if you're creating an exemption for this, why not for that? I mean, and those are questions that we can have in conversation with any bill.
I was gonna say another example of that, and right, people really like to get into the weeds, but how is this different? I'm just throwing this out there, than a pond on someone's property? Or, how is it any different than that?
Yeah, and ponds are exempted.
Right,
So,
so I was
right.
just, I grew up, we have a large, a fire pond in Charlotte, and we don't fence it or.
Right.
Anyone can we always were careful when, like, my sister's kids and stuff would come over, that they didn't just go off by the pond, so I don't know.
You'll see the exemptions on the next page.
Oh, sorry,
Yep, no, that's fine.
jumping ahead, but anyway.
No, but the point
We're at
is,
line 17.
yes. So this is going on with the particulars of enclosure. So we just pointed, what about the enclosure? It's got to have a 5-foot wall, right? No gaps or openings that a child could crawl through. And number 3, see, there's those subdivisions, 1, 2, 3 are all elements of what apply to this enclosure. The third one is, well, it has to have a gate that opens outward, right? The gate opens outward, and that outward opening gate has to have, and this is also a common convention, you'll see in line 18, the gates shall open outward from the pool and, you see that and on line 18, because it's got to have outward opening gates, excuse me, and one of the two following things, A or B, right? Those gates have to be either A, self-closing and self-latching, with the latch located at least 54 inches above the ground. Or if it's not self-closing or latching, B, you can see it could also be secured by a padlock that requires a key or something like that. So the gate's got to have a gate that opens outward, and that gate has to be either self-closing or have a lock on it. So these are all the elements of what it means that the enclosure requirement applies. So that brings us to subsection D, line 6. And that is you'll see the language there says, this section shall not apply to. So a synonym for that might be exceptions, right? These are exceptions. Whenever you see that language, you mean, oh yeah, these are exceptions that penalty doesn't apply to. And you've got 3 different ones listed there. First one is basically water delivery systems is kind of what the general picture of what that exception is. Second one, this is the ponds, waters, agricultural ponds and waters, that sort of thing. And third one is kiddie pools. So these are ones to which this fencing requirement does not apply, or any of the other requirements that we just talked about. Last of this new provision of law, this new chapter, you'll see is subsection E, and this also was talked about a little bit earlier. This is the idea that that a municipality can adopt a more stringent ordinance if they want to. So this isn't saying, a municipality can't do something a little more strict if they choose to do so. Well, this is essentially saying that the state law, if it were to pass, we call it a floor. This would be a floor of responsibility. But municipality can go higher if they want to, and this provides them with that ability. Excuse me. So that takes us out of what the prohibited conduct is. Now you get into, well, what's the consequences? And the consequence, we sort of talked about this already. There's a provision on penalties, line 16. This new section of law that goes in the same chapter provides that if you violate, if you don't enclose it the way you're supposed to, then you're subject to the civil penalty of not more than $100, each day being a separate violation. And lastly, in section 2 is in a sense.
Before we get to section 2,
Yeah.
Senator Burris.
Do all penalties, if they are not designated otherwise, go into, where do they go?
You mean what happens to the money? Yes. These, you're right, assuming it's not designated otherwise, because you do have the authority to put something specific in there as to where you want their revenues to go. But assuming they don't, they go into, I believe there's a percentage breakdown between, the operation costs of the Judicial Bureau and I think either the court, and I think there's a residue for the general fund, I believe, for civil penalties. But that's off the top of my head, so I'd want to check on that to be sure and get back to you.
So just as a follow-up, in committee, could we say all, not more than $100 a day to be designated into a fund for like water safety education?
Yep, sure. Absolutely.
Senator Lavalley.
Thank you. Representative Labor brought up a good point about, according to this, I mean, if I'm a law enforcement officer and I see the pool's abandoned, I can go and slap a fine right off. And the individual might not know anything about it. So if we wanted to put something in there that says that, once she's been warned, then you can start finding them.
Mm-hmm.
Is this something now this bill was already passed? Oh, it has, okay. So if I wanted to put an amendment to that, of course, I could put an amendment to that bill.
Absolutely. Yep.
with that in there.
Yeah.
Okay.
During the discussion on the bill from the time we would pick it up before we would vote on it, I wouldn't call it an amendment, call it a result of conversation of cooperation of, whatever, that's litigating, or not litigating, legislating. Litigating would happen not on this bill, but, anyway, that would be something that we could add that. And that does something else to the bill at the very end in terms of this becomes the bill as amended. But, we can deal with that later. I just want to let Representative Lamont have a question, and then we're going to take a break. But we'll finish this up right now and
Just to clarify so in line with the conversation that was just taking place, a result of conversation versus them, so if we were to break down language to clarify like what is young or what is like whatever.
Yeah.
Does that happens as part of the conversation? And so it doesn't have to be a separate addition. It just, when you're doing the work and the language change, that gets added in and you don't have to take additional steps to put in extra proposals when you break down definitions like that, right?
Yeah.
Correct, sorry.
Yeah, no, you're on the right track, absolutely. And it might be helpful to note that you see, I think at the top of this document, so the top of mine, it says bill as introduced, right? It is extremely rare for the bill as introduced to be the same bill that comes out of committee. That's the bill as introduced. That gets the conversation started. And then, I would say most often, and not that this is the only way you have to do it, but most often, the committee discussion happens, you decide what changes you might want to make. And then I, or whoever your attorney is who's working on it, will draft what we would call a committee amendment. And that could be a strike-all amendment, which means that it means you're starting from scratch. It means you're not going to see, the new document you see will say the committee proposes to strike everything after the enacting clause and insert in lieu the following, and you'd start fresh. And that particularly happens if you have, more than one tiny little change. If you've got a bunch of them, it's much easier to do it that way. Plus, that's another context issue. You think about it, the bill's going to come out of here and go to the floor, and people out there are going to want to understand what it is. And if you took the other approach, which is instances of amendment, in other words, let's say you were changing the word, young or young child, you were going to say, under 8 years of age or whatever it was. And if you were to say, the committee proposes to amend after the word child by inserting the word under 8 years of age, and you could technically do that. Well, then someone on the floor hadn't seen the rest of the bill might think, well, what does that mean? What's that referring to? But whereas if they see the whole language, then they'll understand, oh yeah, that's because, that's, to whom the statute otherwise applies.
And that's a presentation thing that you'll see if you look at the calendars that get published and when the bills are going to be read. So we'll get back to that. I mean, but if we were to keep working on this and we said, let's make those changes, next time Eric came back in, it would be version 1.1.
Right.
And then if we made, and it could be version 1.2 if there are minor changes, but if there starts to be any kind of substantial change, it might go to version 2.1. So and that's how we'll track the changes. And so when we vote on this bill, it'll be, I would ask for a motion to accept this bill as introduced or version 1.1, as amended, et cetera, et cetera, et cetera. Okay. And so that's stuff that we can work on. But I want to take a break now, but I just want to make sure to thank you for taking us through this piece, because the next time we do this will probably be next week on a 40-page bill. So it'll be a little bit different than this, but it's the idea is at this point, like I'll say when we have a larger bill is to limit the questioning until the walkthrough is done, simply because we just took a half an hour to go through or more to go through 4 pages
Simple little bill.
Exactly. And so that's just part of our process. It'll be fluid, but this was just really the base thing that I wanted to share with you, just to have the understand. Questions are never verboten or forbidden, but they are, in order to get through walkthroughs, it's better to just let the attorney present. And again, because they're not going to answer policy questions. Why would we do this? This is an invasion of privacy or what have you. That's not his problem or his fault. It will be to listen to us and then scribe the changes that we ask for. So and give the legal advice that is needed. Anyway, could we go off live now? Thank you, Eric.
Yes.
Thank you.